Okay, everybody, I hope everybody's doing well. This is our lecture, our fourth lecture, and this is going to be a lecture on criminal law. Okay, if you look at your outline that you have in front of you there, and number one is the three ways a person can be criminally liable in Alabama are intentional, reckless, and criminal negligence. There's the word knowingly in there also, but this is what we'll go with right here. So intentional, reckless, and criminal negligence. So talking about criminal law now, we're not talking about torts, we're not talking about civil action, we're talking about crimes now. And we're talking about the substantive criminal law. The substantive criminal law is, remember, the elements of the crime. It's not the procedural criminal law, but the substantive law. You people are going to be criminal lawyers. You'll go to 3 or 4 years of law school. You'll take one semester in criminal law. You'll take 1 semester in criminal procedure, and that's going to be your criminal law courses. So we're going to do this in about an hour here, but you'll have a pretty good understanding of criminal law in the state of Alabama. Now, we talked about before, like you got different laws in Tennessee. We've talked about that before in Georgia, Florida, Mississippi, different states, and in particular murder. Okay, and I've tried murder cases in several states, all the southern states. And like in Tennessee, you have first degree murder, second degree murder, first degree manslaughter, and second degree manslaughter. And the same way in Georgia, in Florida, and Mississippi. You do not have that in Alabama. I've told you, I think in the first lecture, we talked a little bit about this. In Alabama, 13A62 says a person commits a crime of murder if they intentionally cause the death of another person. There it is. In those other states, you require first degree murder is the intentional killing of another human being with malice, forethought, and premeditation. So I'd rather try a murder case, of course, in Tennessee and in Georgia, Florida, and Mississippi, because to convict you of first degree murder in those states, the state has to prove premeditation and malice, forethought. And they don't have to prove those. Premeditation is a lying in wait. Malice, forethought is a fixed hate, ill will, desire to hurt. That's the definitions. And in Alabama, the state don't have to prove those. The state has to prove intent in Alabama. 13A62, a person commits a crime of murder if they intentionally cause the death of another person. The law says you intend to do the probable and consequences of your act. There's a presumption that you intend to do the probable and consequences of your acts. So that means if I pull out a baseball bat and I swing it at somebody's head, there's a presumption that I intend to kill them or hurt them real bad. There's a presumption that I intend to do that. They can't take the top of my head, I'll put my brains out for the jury, but there's a presumption. That's a rebuttable presumption. When we talk about evidence, we talk about irrebuttable presumptions. That's a rebuttable presumption because I can rebut it. And maybe I was insane or whatever, say self-defense, whatever. We'll talk about that some in just a minute. Okay, so this word intent, and now you have to prove intent. And we'll talk about self-defense, we'll talk about accidents, insanity as a defense. We'll talk about that some, okay? So that's number one, okay? And I'm going to use the homicides as an example here, okay? So 13A62, person commits crime of murder if they intend to kill another person. All right, that's the first way you commit murder in Alabama. Second way, it says a person commits crime of murder if under circumstances manifesting extreme indifference to human life, he recklessly engaged in conduct which creates a grave risk of death and a death ensues. It's a lot of words. That's the word verbatim. That's verbatim out of the criminal code. The definition of recklessness is where you're aware of and consciously disregard a substantial and unjustifiable risk that a circumstance or result will occur. Okay. Now, the law further says you cannot become voluntarily intoxicated and get out of the awareness requirement. Okay? We'll do a few test questions somewhere in this lecture, so you can kind of put yourself at ease on that. All right. So now That's different in the other states, but in Alabama, okay, now you have the intentional murder and you have the reckless murder, okay, but in the murder statute, it says you have these words, like I've just said, under circumstances manifesting extreme indifference to human life, he recklessly engaged in conduct which creates a grave risk of death and the death ensues. And the definition of reckless, I just told you there a while ago, okay? Now, let's say this. Let's suppose that I do this lecture here, and after I do the lecture, I go out and I drink a half a bottle of Johnny Walker Black Label, which I would not do, but let's suppose I did. And then I go out here and I'm going 110 miles an hour on down Whitesburg, I run a red light and I kill somebody. Did I intend to kill that person? No. But will I be charged with murder? Yes. What kind of murder? Reckless murder, okay? Let's see if that definition I just told you, okay, which is in the Alabama Code, 1386-2, let's see if that definition of that law, now the law and the facts have to come together to convict somebody. It's not, you know, if you have facts but you don't have the law, you can't convict. You know, and the jury determines the facts, the judge tells the law. The judge will charge the jury on the law, but the jury determines the facts of the case, okay? So let's go through this. We know we know the facts. I got drunk, I'm driving down Whitesburg 110 miles an hour, I run a red light and I kill somebody, all right? Do those acts meet this definition? A person commits the crime of murder if, under circumstances manifesting extreme indifference to human life, he recklessly engaged in conduct which creates a grave risk of death to another person and death ensues. The definition of reckless being where you're aware of and consciously disregard a substantial and unjustifiable risk that a circumstance exists or result will occur. Now, if that's a lot to you, that's all the jury gets to hear, by the way. Now, I can get up and I can explain to the jury, the prosecutor can, but the judge can only read that law. That's it. That's what the jury hears. So, based on those facts that I told you that I did, does that definition meet those facts? And I will say that I will be charged with murder, reckless murder. Carries a sentence of 10 to life, okay? Intentional murder, of course, is where I pull out the gun, shoot somebody, baseball bat, swing it at their head, kill them, cut their throat, whatever. That would be an intentional murder, okay? I didn't recklessly do that. When I picked up the baseball bat and I swung it at somebody's head, wasn't reckless. I intended to do it, okay? So, you know, the crime, you'd have to be intent or reckless now, you know. So now the one where I'm driving down the road drunk and run the red light and kill somebody, I didn't even know that person. I wouldn't hurt that person for anything in the world. I didn't intend to kill that person, but I'm going to be charged with reckless murder, okay? Now, under the intentional murder type, it could be capital murder. Capital murder is where there's some other crime like a murder in the commission of a rape, robbery, arson, burglary, shooting into a car, shooting from a car, shooting in a house, killing a child, killing two or more people in the same acts. If you would, like if there's three people, shoot them and kill them all three at the same time. You got a number of different ways shooting a police officer. Number of different ways. I believe 19 different ways in the state of Alabama you can get the death penalty in the state of Alabama. Okay, so that can't be a reckless murder. There has to be an intentional murder and something else that goes with it. Shooting in, like I said, if I shoot into a car, I didn't negligently do that already. I shot in that car, okay, and killed somebody. All right, that would be a capital murder, okay? So the capital murder is where if you get convicted of capital murder, you can only get life in prison without parole or the death penalty. That's it. All right. Murder, okay, you got capital murder at the top. Murder, it's 10 to life, class A felony. If a weapon is used, a firearm is used, it's minimum 20 max life, okay? So now you also have what you call felony murder, all right? I guess the best way to describe this is we just got through the Casey White case. I've told you about it a little bit before, and we had some very good lawyers working with me on that case, Marcus Helstowski, Nick Heatherly, Nick Law, and Robert Tootin. handled, and Wilkes was the paralegal that was in charge of the legal research on the felony murder case. He was charged. That's where a jailer had broke him out of jail. They stayed on the run for a while, and then they were police got after him in Indiana. They had a wreck, and she shot herself. She committed suicide. Vicky committed suicide. Casey got out of the car and was arrested. He was charged with escape. He was charged with felony murder and capital murder. Capital murder on another case in Lauderdale County, where it was alleged that he broke into this lady's house and he killed her, did a burglary and he killed her. All right. So felony murder is different than anything else. He was charged with felony murder. That's if you're involved in a felony and somebody is killed, you can be charged with felony murder. Now, under that case, the reason he was charged with felony murder is because Vicky, she killed herself when they were being chased. They had the accident. She pulled out a pistol, shot herself. He got out of the car. They said, okay, the death would not have occurred. The prosecutor said and he charged with felony murder. Said the death would not have occurred if you hadn't been involved in a felony, i.e., escape. Okay, all right. So that was their argument. A lot of pretrial motions, a lot of preparation, a lot of research, but we end up that case got dismissed because we argued that was a suicide. They argued it was a felony murder, that there was a death and there was a felony, and therefore it's felony murder. We argued that it was not felony murder because she committed suicide, and the state ended up dismissing that case. He ended up pleading guilty to the escape. She took him out, and he left with her. He pled guilty to the escape. The other capital murder case was dismissed. So when we went into the case with a felony murder, a capital murder, and an escape, the two murder cases were dismissed, and he entered a plea to escape. So you have the capital murder, you have murder, you have felony murder. Okay. Another example of felony murder. Let's suppose, and there was a case in South Alabama on this, and it was on one of the Showtime stations. It was about it. They did a documentary on it, on felony murder in Alabama. Not just that case, but felony murder in Alabama. Felony murder is an archaic law. The only country that has it is us, and it's the United States. They had it in England. They did away with 1957, I believe it was. But it's like where you had a young guy he was outside and he was the lookout, and a guy went into a house, then came to do a burglary. He came out of the house, and the police officer killed that person. And the young man that never went into the house, it was just the lookout, was charged with felony murder. In other words, a felony was being committed, that is the burglary, and there was a death. The police officer killed the other person, but the young man was charged with felony murder, and he was convicted. He got 30 years, I think, in prison, and it was upheld on appeal. Again, we have the felony murder doctrine. And so if you're involved in a felony and somebody gets killed, then there's going to be felony murder. Now, we are getting in the Casey White case. Vicky committed suicide. She didn't, there wasn't, nobody shot her. She killed herself. But the state argued that there was a death and it should have been felony. That's what they argued, but we contended otherwise, and the case ended up getting dismissed. So you got capital murder up here at the top in the homicide case. You've got the murder case, intentional murder cases, and reckless murder cases. And under that, you have felony murder, and then you have manslaughter. Now, again, in Alabama, you don't have first-degree murder, second-degree murder, first-degree manslaughter, second-degree manslaughter. I won't go over all those. If I was trying this case and doing this lecture in the state of Tennessee, I would tell you about that and elements of it. I told you about first-degree murder, but second-degree murder is killing in those states is killing another person with malice forethought. It don't require the premeditation. But in Alabama, you don't have those words. The state don't have to prove premeditation, malice aforethought. They just have to prove intent. So we've talked about, we're coming on down now to manslaughter, 13.6.3. Okay, it says a person commits a crime of manslaughter if they intentionally cause the death of another person, but they do it due to a sudden heat of passion caused by provocation recognized by law. Okay, so two guys in a bar. All right, they're friends, maybe best friends. Okay, young lady comes in, and I won't embarrass anybody, I promise. This is not the way to play out in real life, but I won't embarrass anybody. So, young lady walks by, and one of the guys says to the other, "That's an attractive young lady." And the guy says, "Yes, yeah." And he says, "I would love to go talk to her. I'm cleaning it up." And the guy says, "Well, that's my girlfriend." And he says, "I don't care who she is. I'd like to talk to her." Boom, knocks him off the bar stool. Okay, guy gets up off the ground, pulls out a gun, shoots him, and kills him. Did he intend to kill him? I got knocked off the bar stool, and the guy that knocked him off the bar stool now is dead, because the guy he gets up off the ground, pulls out a gun, and shoots him. Boom. All right, right in the heart. Okay. All right. Did he intend to kill him? The law says there's a presumption that you intend the natural probable consequences of your act. If you pull a gun at somebody, you pull the trigger, there's a presumption that you intended to kill him or hurt him. Okay. So that's the intent. All right. Was it due to a sudden heat of passion? That's the time for the passion. That's the definition for that, sudden heat of passion. Time for the passion to cool and the reason to reassert itself. By the way, if you're sitting there and you're listening, you got to do better than that, Lord. You got to put it up there better. Put some math or physics or something up there. Give me a better definition. That's it. That's what the jury's got. You know, that's the facts. The facts are two guys. I'm just telling you, two guys in the bar. It's facts. All right, knocks him off the bar stool, comes up and shoots him, and boom, dead. Did he intend to kill him, and was it due to a sudden heat of passion caused by provocation recognized by law? Now, there's two types of provocation it can be. The provocation can be the assault, which you have here, or catching your wife in the act of adultery, not your girlfriend. If you catch your wife in the act of adultery and you kill somebody, that can reduce it from murder to manslaughter, okay? But not your girlfriend, not your fiance, not coming out of the hotel room. All right, you kill them coming out of the hotel. You didn't catch them in the act. It's going to be murder. That's just it. Okay, so there's two types of provocation. By the way, words, no matter how probative, no matter how insulting, no matter how vicious or vile, never reduces a case from murder to manslaughter. Somebody can call you the ugliest names in the world. If you say, "I'm gonna kill you," boom, you kill them. Okay, is that manslaughter? No, that's murder. Okay, because you don't get a reduction of insult because of cuss words and insults. It has to be the assault or catching your wife, your husband, in the act of adultery. Okay, that could reduce it from murder to manslaughter. Keep that thing of words in mind there, because so many people, I've had, again, 48 years, and I've done many, many murder cases, and some people kill you over cussing them out, saying ugly things to them, and they'll kill you. Well, that don't reduce it to manslaughter. It's still murder. You better have it done in defense, like self-defense or something else. The words not going to cut it. Don't get you off. That somebody was David dog cussed me, called me a name, insulted my mama. Well, bad, but you can't kill somebody because of that. Okay, it don't reduce it from murder to manslaughter. All right, so that's the intentional way of committing manslaughter. You intentionally kill another person, but you do so due to a sudden heat of passion causing provocation recognized by law. What's the second way you commit manslaughter in Alabama? It says this, 13A.6.3, a person commits the crime of manslaughter if he recklessly caused the death of another person. And you're sitting there right now, just like a jury, And you're thinking, you just said that a while ago. You said that was murder. No, had some more words with it. I said, and murder was a person commits crime of murder if under circumstances manifesting extreme indifference to human life, he recklessly engaged in conduct which creates a grave risk of death and death ensues. Okay? Had more words to it. 13863 manslaughter says a person commits crime of manslaughter if he recklessly caused death of another person. What's the definition of reckless in manslaughter? Where you're aware of and consciously disregard a substantial and unjustifiable risk that a circumstance this or result will occur. Well, that's the same definition of reckless. You didn't murder. Yeah, but had more words up there, didn't it? Are you getting the drift of how this thing called criminal law, how trial works out here? I mean, it's just that. Now, by the way, back to my situation where I hadn't done this, but suppose I had drunk half a bottle of Johnny Walker Black Label, and I go out here and I run 100 miles an hour, I'm drunk, run red light, kill somebody. We already said that I'll be charged with murder. Could I be found guilty of murder? Yes. Okay. What about the judge will charge the jury, though, on the lesser included offense of murder and will charge them on manslaughter because of just what I told you. The judge will say, ladies and gentlemen, there's a lesser included offense to murder in this case that you can find the defendant guilty or not guilty of. If you find the person not guilty of the murder, you can then consider manslaughter. So could I be found guilty of manslaughter? Same set of facts. Could I be found not guilty of murder, but guilty of manslaughter? And answer, yes, because of reckless. And it's just words. Okay? Are you following me? Manslaughter is 2 to 20. 2 years to 20 years. Okay? Now, let's keep going. All right? Let's talk about criminal negligent homicide. Criminal negligence. 13864, a person commits crime of criminal negligent homicide if he causes the death of another person due to criminal negligence. What is criminal negligence? That's to a failure to perceive a substantial and unjustifiable risk that a circumstance this or result will occur. Remember, reckless where you're aware of and consciously disregard a substantial and unjustifiable risk. Criminal negligent homicide is where you fail to perceive a substantial and unjustifiable risk that a circumstance this or result will occur and a death ensues. So what's the difference between reckless and criminal negligence? Just the words aware of and consciously disregard versus a failure to perceive. Just those words. What's the difference? Well, if it's in my situation, it could be if I'm found guilty of criminal negligent homicide and I'm drunk, it could be a Class C felony and I couldn't get no more than 10 years in jail versus 20 years if it's manslaughter and life in prison if it's murder. So those words can mean a whole lot. Let's suppose it's something where let's suppose I just pulled out a gun and I'm drunk and I'm at a party and I pull out my gun. Look here, my new gun, everybody, and I'm playing with it and twirling it and it goes off and kills somebody. All right, I'd probably be charged with reckless manslaughter, but I'd probably be found guilty of criminal negligent homicide. In other words, my lawyer, I hope, would argue that I was not reckless. I wasn't aware of and consciously disregard the substantial unjustifiable risk. I just failed to perceive a substantial unjustifiable risk. So aware of versus failure to perceive. Those words could be the difference between murder, manslaughter, and criminal negligent homicide. Aware of versus failure to perceive. Who decides that issue there? The jury. So back to my situation, where I'm charged with reckless murder. We already know I could be found guilty of reckless murder. I could be found guilty of reckless manslaughter. Or the judge could say if you find the defendant not guilty of murder and not guilty of manslaughter, you can consider the offense of criminal negligent homicide. So the jury could come back with guilty of criminal negligent homicide. By the way, if you're driving drunk, then you'd Class C felony. But in the situation where I use my gun, it could just be a misdemeanor, where I couldn't even go. All I could go is a year in the county jail. I couldn't be sent to prison. Criminal negligent homicide would be a misdemeanor in that situation. Okay, so you see what the difference could be. I mean, the difference can be life in prison 20 years or a situation where you get no more than a year in the county jail. Just on words and on jury. How important is jury selection? Hope you see them is pretty important, okay? Those 12 people make that decision. They decide those issues. So the same set of facts, me driving down the road like that and being the same set of facts could be murder, manslaughter, or criminal negligence and homicide. Okay? So there you go. Intent, we know what intent is, we know what reckless is, and we know what criminal negligence is. Now we could use that on a lot of the different crimes, but we picked out the homicide because that's I think the best explanation of them. I've done so many capital murder cases. I've told you before, but if I don't, I'll tell you. You people are going to be lawyers. You're going to be criminal lawyers, and I've represented governors. I've represented powerful people in my 48 years, but the most difficult thing to do is to stand up and beg a jury not to kill your client. I've done that a lot of times. That's just, and by the way, when a jury finds your client guilty of capital murder, that same jury then hears the penalty phase, and that same jury then decides whether or not your client's going to live or die. So they've already found your client guilty of capital murder, that same jury. Then they go back. You have another kind of a mini trial, open statements, and you do the penalty phase of the case, the state puts on aggravating circumstances, and you put on mitigating circumstances, reasons you would not kill my client. State the aggravating circumstances, the reason. And by the way, it's not a numerical count. It's not on test, but you probably need to know this. It's not a numerical count. You may have 20 mitigating circumstances, but the jury can say, well, the one aggravating circumstance that your client kidnapped this person and killed him outweighs all the mitigating and give the death penalty. Okay, so that's kind of how arguing for a person's life. That's different than anything. If people are going to be criminal lawyers, or prosecutors, you may be arguing that for a jury to take a life. And that's my son was a prosecutor. He's a pilot now, but he was a prosecutor, and he raised in a house with a lawyer, did a lot of criminal cases. And I always said, son, be the best prosecutor you can be. If that's what you're going to be, you be the best. You be the best at it. So whatever your career, whatever way you decide to go, if it's in the law, be the best at it, best that you can be. All right, so we got those. We got the intentional, and we got reckless and criminal negligence there. Let's go to number 2. Every crime requires a mens rea and actus reus. All right, that's your first lecture in law school. The professor's going to say that to you. Every crime requires a mens rea, a criminal intent, that's mens rea, and an actus reus, a criminal act. Boom, they're going to say that. And then they're going to get down toward the end of the course, and they're going to start talking about terms that you know right now, reckless and criminal negligence, because that's not a mens rea at all. That's reckless and criminal negligence and homicide don't require a mens rea, a criminal intent, because it's a reckless, it's criminal negligence. I didn't intend to kill the person when I ran the red light. So when you start law school and the professor says every crime requires a mens rea and an actus reus, I put that in there because it's in every textbook, okay? But then when you get to, and you already know because you got a teacher that's been practicing law and trying so many cases, you already know that's you can convict somebody without a mens rea and actus reus if they're charged with reckless or a criminal negligence act, okay? But I put that in there so, so I got it covered because it's in your textbook there, okay? State must prove a corpus delicti in every case. The corpus delicti is just simply that a crime has occurred. If you're an investigator and you get called out to a dead person, a 72-year-old guy dead in a swimming pool, okay, well, and while you're out there investigating what's to investigate. A neighbor comes up and says, you know, his wife's 27 years old. Okay. They were in the process of getting a divorce. Okay. He just got $10 million in life insurance, on his life. 2 weeks ago, she insisted on it, said she would, and I heard her say it, she wouldn't stay with him if he didn't get $10 million life insurance, and he did that 2 weeks ago. Do you have a corpus delicti? Do you have a crime there? No. Looks bad. You don't have a crime there. Okay? Now, suppose you take him and do the autopsy, but I've been to a number of autopsies, but if people are going to be a criminal lawyer, I'd suggest, or prosecutor, it would be good to attend an autopsy because you find a lot about your case at an autopsy. In other words, if you go to the autopsy, if you're fortunate enough to your family calls you, hires you, before you talk to the client's in jail, you go to the autopsy, you go talk to your client tells you what they did, and you know what the angle of the bullet wound or the stab wound was because you were at the autopsy. And I've been to a lot of them. All right, you tell your client it didn't happen that way. You've seen the physical evidence. Now tell me the truth here. Back to our case, corpus delicti. They take the person in, they take the blood, they take the different fluids from the stomach, they take the contents of the stomach and fluids, whatever, and you do fluids from the eye, and they do all that, and they come out and say, this person had arsenic. This person been poisoned. Okay, do you have a corpus delicti? Yep, you got a corpus delicti. You got a crime now. But now you got to prove who did it, don't you? You got a crime, but who did it? And it's like I hadn't told you this, but there are crimes in your county that the law enforcement people, they know who did it, but they can't prove it. When we talk, our last lecture is going to be, you say, well, wait a minute, no. You can have all the suspicions in the world, but you got to prove your case beyond a reasonable doubt. That's reading families. If you go a prosecutor or a homicide investigator, the family, we know she killed him. We know he killed her. Go make the arrest. Arrest him. We won't go to trial. You go to trial, then they found not guilty of the case. You don't even have enough to get it to the jury. The judge says, wait a minute, there's not enough evidence to even prove a prima facie case here. Not even enough to get it to the jury. Well, you got one shot at this thing. It's called double jeopardy. Once you try it and they get off, it's over. And then you find the evidence 2 years from now that to convict them, well, you can't bring it back. You done tried them. You've already tried the case. They've been found not guilty. So you got to have evidence. You can think this person did it. Knowing is not proof. If you don't have evidence that you can get in before a jury, and I promise you that defense lawyer is going to do everything they can to keep that evidence out. Okay? Now that's just the way it is, all right? So the defense lawyer is doing what they can to keep evidence out. If the jury can't hear evidence, they can't convict, can they? All right, so now we know in our case we got a homicide, but we got to prove who did it. We can think she did it. I believe she did it. But let's not prove beyond reasonable doubt. What if you find a vial of arsenic in her, in her medicine cabinet in her bedroom? Does that prove she killed him? Nope. You might have probable cause. You might arrest her, but you can't convict her. That's not enough to convict that woman. I'd take that case. Case wouldn't go far at all. Okay. In that case, if you're an investigator, you'll need to find a boyfriend. All right, and there will be one. Okay. You find that person. That'd be a pretty easy person to find. And you talk to that person, and you tell that person about capital murder. That a murder for hire, you can get the death penalty for that. If he's involved in this offense, he could get the death penalty, and you'd be willing to talk to him and cut him some slack if he won't tell you the truth. Otherwise, you're gonna arrest him. You may not have enough. You got enough maybe to arrest him, but not to convict him. But he don't know that. And then he says, yeah, here's what we did. We got the arsenic, and, and she got it from this place, or I went and got it for her. So you make a deal with him, testify against, give him a 20-year sentence. He testifies against her. But that's how you're going to have to get her. If she keeps her mouth shut and he keeps his mouth shut, you ain't. I mean, you can think, but they ain't going. You're not going to ever convict them. You probably you had enough to arrest, but not. You'd have probable cause to arrest, but not to convict. Okay, so that's what a corpus delicti is. Every crime, robbery, rape, arson, murder, requires that you have to have a crime. That's the corpus delicti. The corpus delicti is the body of the crime. Well, that sounds, well, that's just like, that's only in homicides. No, that's every crime requires a corpus delicti. All right, the next number 4, the defendant has the burden of proof in the insanity defense by clear and convincing evidence. All right, now let's look at the defense now. We've talked about some of the offenses, especially murder, and let's look at the insanity defense, okay? All right, so suppose you got a client and you say that you plead your client not guilty by reason of mental disease or defect, not guilty by reason of insanity. I've had a lot of these cases, okay? I've had a case where a young girl killed her 2 little children, killed 6 months apart. One of them, the first one, they didn't know anything happened, but the second one died, and they exhumed the body, and both of them had their heads bashed in. And she was paranoid schizophrenic. She was hearing voices that was telling, the devil was telling her to kill babies, to kill her children. Okay, so when insanity, and I had a case where a young lady was charged with starving her 3 children to death, and several years ago, in this community of all communities in America, charged with starving your children to death, and the crime scene was terrible. 3 little children dead in different rooms, and they had actually starved to death. So you have situations like that where the defense would be insanity. You had a case that you had several years ago where a professor killed some other professors, and one of the lawyers in our building here was one of her defense lawyers. Her defense was insanity. Represented Jeffrey Franklin, who killed his mother and daddy and attempted to try to kill his brother and sisters. His defense was insanity. I've had a number of cases where my defense was insanity. Now, the only time in criminal law where the defendant has a burden of proof is where insanity is the defense. No other time in law, in the criminal law, does the defendant have the burden of proof. The defendant never has a burden of proof. The defendant does not have to prove her innocence. The state must prove her innocence her guilt beyond a reasonable doubt. If my defense is insanity, now the state has to go first, prove the murder. If my defense is insanity, then I got to put psychiatrist, somebody up on the witness stand to prove 2 things. Number 1, that my client has a severe mental disease or defect. And then number 2, because that she did not understand the nature and quality or wrongfulness of her act, i.e., she didn't know right from wrong. Now, I've had cases where my client pled my client guilty or not guilty by reason of mental disease or defect. I had a psychiatrist say my client had a severe mental disease or defect. But it's got to go further than that. I got to prove that because of that, by clear and convincing evidence, that my client didn't understand the nature, quality, or wrongfulness of her act, i.e., she didn't know right from wrong. So if my client killed somebody, in the Amy Bishop case, when she shot the professors, she went upstairs, she changed her clothes, hid the gun, called her husband, beat at the loading dock. Okay, does that indicate that she knew right from wrong? I'll just ask that to you. If I had, when I represented Jeffrey Franklin, killed his mother and daddy, one of them deaths with a hatchet, one of them deaths with a sledgehammer. The crime scene was horrific. But when the police came, he ran. Now, it's not enough to show your client has a severe mental disease defect. You've got to prove, number 1, your client has a severe mental disease defect, but number 2, because of that, your client didn't understand nature, quality, and wrongfulness of his act, i.e., he didn't know right from wrong. So anything your client does leading up to, during, or after that crime that shows that he or she knew right from wrong. It don't matter that they got a severe mental defect. They knew right from wrong. If that's what the state usually hangs their case on. I've had cases where people go in and do things, and then they got people that go out and help them hide evidence. Well, if you didn't know you was doing wrong, I've had cases where they kill somebody and just stand there, and I had one where she just started talking to Lucifer. She's killed a person, and just when SWAT teams come, she's talking to Lucifer. She killed a preacher, and here she's been shot another person, and that she just talking to the devil. Okay, the devil told her to do it, and she was talking to him. She's paranoid schizophrenic. Okay, and so that you got, she didn't run, didn't hide. She just, the one where I told you about the young lady killing her two little babies. The devil, she was talking to the devil, and by the way, she had a state-appointed lawyer, and they had hired a court-appointed, or they didn't hire, but got a court-appointed psychologist. I hired Dr. Mary Kangas out of Yale to come down here. A church came in and asked would I represent her because they were going for the death penalty, and so I hired Dr. Mary Kangas from Yale University. Came down here and he said, "This woman is paranoid schizophrenic." And by the way, when she had the appointed lawyers, that person had said that she did not. She did not have a severe mental defect. Dr. Mary Kangas from Yale University said, yes, she does. And we proved that, and she was found not guilty by reason of mental defect. We'll maybe talk sometime what happens to them at that point, what happens to them when they're found not guilty by reason of mental defect. I've had a number of cases like that too. Okay, so when insanity is defense, the defendant has to prove the insanity by clear and convincing evidence. Now before we go further, let's get some test questions here out of the way here so that you can know kind of where we're going here. Let's see here. Go. Takes me a while to find it. Bear with me here. All right, let's see here. Let's see here. All right. You ready? The defense has the burden of proof in an insanity defense. This is the test question now. The defense has the burden of proof in an insanity defense, A, beyond a reasonable doubt, B, by a preponderance of the evidence, C, clear and convincing evidence. What's the answer? We don't have to go to D to do. We got C's the answer. Okay. Talking about Rico there, and we'll get that. Blank is defined as taking another's personal property. I hadn't covered this yet, but I'll cover it right now then. Here's your test question. Blank is defined as taking another person's property from his or her person, or in his or her presence by force or intimidation with the intent to deprive him or her of it permanently. A, burglary, B, larceny, C, robbery. The answer is robbery. By the way, robbery is, people said I've been robbed. If somebody walks into let's say you're in class and you leave the classroom for the break and come back and your cell phone's gone. If somebody may have stole your cell phone, that would be theft. If somebody puts a gun to you and says, "You give me that cell phone, I'm gonna blow your brains out," that's robbery. Okay, that's a crime against the person. So that's the reason robbery is a Class A felony, 10 to life, whereas theft is not a class. Depending on the price, it can be even misdemeanor, the value of the property. So you can see there that when people say I've been robbed, no, you've had something stolen. But now if somebody puts a gun to your head, you've been robbed. Okay, so that's we've got that covered there. Let's see here. I think let's see if I got anything else on there. There's a few more questions, but it's something that we'll cover here as we go on further here. Yeah, we got a few more in there, but I will say that I'll say that when I finish my lecture here, I'll say, or during the lecture, I'll say, now that right there that's a test, sound like a good test question. So just follow me in my lecture, okay? All right, so let's look at the next thing here. All right, once the issue of self-defense is injected, the state has the burden of proving the defendant did not act in self-defense. Now, see, self-defense is different than insanity, okay? Remember, insanity, if I plead insanity, the defense has to prove those two things. I said, number one, severe mental defect, and because of that, the client didn't know right from wrong, all right? So that's not the issue in self-defense. Let's go back to our bar, what we was a while ago. A young lady comes in, words are spoken, knocks him off the bar stool. The guy gets up, puts his, he stands up. And the guy that knocked him off the bar stool puts his hand in his pocket. And then the guy shoots him. And when the police talk to him and they read him his rights and they ask him questions, he says, I thought he was going to kill me. Well, what if he didn't have a gun and they searched and he didn't have a gun in his pocket? It don't matter, because here's the law. You ready? You ready? Here's the law. Verbatim, here it is. A person can use deadly physical force if he reasonably believes the person is using or about to use unlawful deadly physical force against him, committing or about to commit assault in first, second degree, any sex offense, robbery, burglary in first degree, arson in first degree. He can use deadly physical force. So the guy knocks him off the bar stool. He's down on the ground. He gets up. He's getting up, and the guy that knocked him off puts his hand in his pocket. And he says, I thought he had a gun, and I shot him. Could that be self-defense? The answer, yes. Okay? By the way, a while ago, manslaughter, what if, when we talked about manslaughter, and the guy, we knocked him off and he comes up and shoots him. What if the guy went out in the parking lot, got his gun, and came back in? Would it still be manslaughter, or would it be murder then? Would it still be a sudden heat of passion? Let's go back to our manslaughter real quick here. Manslaughter and self-defense gets kind of tight there sometimes. So the guy knocks him off the bar stool. The guy gets up, goes out to his car, gets a gun, comes back and kills him. Is it still a sudden heat of passion? Time for passion, cool reason, reassert itself. Well, it could be. What about if he goes home? What if his house is 30 minutes away, drives 30 minutes, comes back, so it's been an hour, comes back, kills the guy? Is it still a sudden heat of passion? Who decides that issue? The jury. I had a case where the guy did it happen. They found him not. Well, they found him. It was manslaughter. They said it was still a sudden heat of passion. Now, that's something you have to argue, and the jury has to believe it. The state said it wasn't. I said it was. And it took a week, but that was to try the case. But that was the issue in the case. Okay. Self-defense, same thing. All right. Self-defense is if you reasonably believe the other person's using or about to use unlawful deadly physical force against you, you can kill them. Now, what if when the police come and the person's dead and they come up to the person that shot him and he says, what happened? And he says, well, he knocked me off the bar stool and he went for his pocket and I killed him. And the police officer said, what did you think when he went for his pocket? Nothing. Well, that's not self-defense. You're back into manslaughter. You're not going to get off of self-defense. But if you said, I thought he had a gun and I shot him. This stuff happens so fast, folks. Let me tell you, you don't have to wait. It's like I always tell people. People say, well, I got a gun. I'm carrying a gun in my purse. Well, the person's coming after you to rape you or to kill you. They're not going to ask you to give you time to go through your purse. That person don't hesitate. You're a good person. You hesitate. That second you hesitate, you're dead or kidnapped. I hate to say that, but I've been doing this. When you represent people that do stuff like this, they don't wait. It's not a matter of, well, it's giving you time. Let me give you time. I'm going to break in your house here. I'm going to give you time to get you, take care of it. No, it don't work that way. Those people, they don't hesitate. Good people hesitate. That's just the way it is. So back to self-defense. That's important. Now, if that person says, I believe he went for his, by the way, The only time the character of a victim of a crime can be introduced is where self-defense is defense. But you can introduce your client, if you're representing that person, you can introduce the character of the deceased person to show they had a character for violence if your client knew that before the incident. In other words, part of them being reasonable was they knew the person they shot was a violent person, then you can put that into evidence, okay? But if they didn't know, you could be public enemy number one, and you don't know that, then you can't, and you kill that person. You can't. You're saying self-defense. You can't introduce their character into evidence if you didn't know it. But if you knew this person that you shot had a reputation for violence, if the woman, she's with a guy and he beat his ex-girlfriend up and beat the girlfriend up before that and almost killed a girl, and she ends up killing this guy. Now the jury's going to wonder why would she be with him, knowing this stuff. But if she knows it, you can put that into evidence against that guy. She kills the guy. You can put his character in, bring those other women and show this guy was a violent guy. All right. So that's kind of something there. We'll talk about that maybe in a lecture on evidence there. Okay. All right. In an entrapment defense, in an entrapment defense, the main consideration is predisposition. All right. Entrapment goes like this. A person is online trying to go with a person underage, trying to arrange something. He gets there and he's arrested and finds out that the person that was the 13-year-old girl was really the law enforcement. And he comes in and he says, I was entrapped. No, he wasn't, because he was predisposed. He was looking for it. You cannot say entrapment if you're predisposed. If a person comes in, let's suppose this could happen. Let's suppose the drug agents sell your client 3 kilos of heroin, and your client buys the 3 from the law enforcement, and then they bust him in charge of trafficking. And your client says, I was entrapped. The government sold me the dope. Well, was he predisposed to buy the dope? Was he a dope dealer? If he was predisposed, the government can entrap him. Now, if you have a case where there was a case, I think out of South Dakota, where the government kept sending this person like 18 different times, sending him stuff, child pornography stuff, to try to get him to act on it. And finally, the 19th time he did, and he was convicted. But the Supreme Court, set aside because it said that he was entrapped. The government entrapped him. He was not predisposed to do this. It was not. He wasn't a dope dealer. They just kept sending him. He wasn't after child pornography. There have been drug cases like that too, where they just keep coming after you. If I would say to you, let's go to Decatur and let's go. I'll give you $1,000 ride to Decatur with me. You say, all you got to do is walk into the house and get something for me. And you say, no. Let's suppose I'm been arrested and I'm an informant. I hadn't, so just for that example. And then the next week I tell you, look, I'll give you $5,000 if you'll do that. Just all you got to do is ride over to Decatur and go in his house and pick up his stuff and bring it back to me. I'll give you that. No, I'm not going to do it. And then I offer you $10,000. No, and then $20,000. And then finally you say, okay. And then you go over there, pick up stuff, they arrest you, and I say, okay, I made a case for y'all, all right? You're probably going to get off with entrapment because I'd have all that recorded if I was an informant. You said no, 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 no. Finally, yes. I think that would be, you were not predisposed to do this. And I was working for the government. I entrapped you. The key word, and that's a test question, by the way. That will be a test question. In entrapment, the key word, the key consideration is predisposition. All right, let's see. The prosecution must provide exculpatory evidence to the defendant if there's a motion for discovery filed, that's if the state has anything in their possession which tends to prove your client did not do the act, they have to give that to you. You can't, remember what I told you, you can't take depositions, you can't file interrogatories and motions to do. You can file a motion for discovery and ask the state to give you, if they have anything which may tend to clear your client, they have to give, that's called exculpatory evidence. They have to give that evidence to you, okay? So that's only fair if they got something that can, if it's a capital case, if they have information that's mitigating, it could be reasons not to vote for the death penalty, they have to give you that too. That's called exculpatory evidence, Brady versus Maryland. Okay, the burden of proof, number 8, burden of proof in criminal cases beyond a reasonable doubt. Number 9, by the way, we've talked about burden of proof before, and you think, well, you mean a person's whole life could be determined by that? Just words beyond a reasonable doubt. Do better. Put a form. Can't. That's it. Beyond a reasonable doubt. About doubt for which reason may be given. Not a fanciful doubt, but a real doubt, a reasonable doubt. And that's it. Number 9, the Racketeer Influence and Corrupt Organization Act, called RICO, was enacted to control organized crimes, investment, and legitimate business. That is a test question. All right. Next, number 10. Criminal RICO requires a pattern of racketeering activity, which is 2 or more racketeering acts within a 10-year period. That is a test question. Okay. So 2 or more acts. So it was done to get rid of organized crime. Okay, but it's really the way that it's used now. It can be used against anybody. But if you do 2 or more predicate crimes, which is just about anything, wire fraud, mail fraud, it's conspiracies, any theft, anything, 2 predicate acts within this 10-year period, then you can not only be charged with those acts, you could be charged with RICO. Now you can see if it's for the mafia and you've got, the criminal syndicate or something, and they're out here and they're doing all kind of fraud, and they're doing, extortion and all the things that they do, and they do 2 or more of those acts in a 10-year period, then it could be RICO. And the sentences are much more severe, and there's a lot more financial fines to RICO. But if you just start applying it just to a regular person, which they do, and the penalty's much worse, then you have, that's where you have so many people serving long prison sentences. It was intended for organized crime, but it's used for everybody. But that is a test question. Number 11, the last one, extradition is delivery of an accused person to another state. It's not worded exactly right there, but extradition is where you have let's say you have somebody in Tennessee, you arrest somebody in Tennessee and they've done a crime in Alabama, you have to extradite them. If they don't waive extradition, the governor of Alabama has to request a warrant from the governor of Tennessee. It's complicated. Generally, if you have a person in Alabama and they have a case in Arizona, let's say, and they get arrested on a fugitive justice warrant in Alabama, generally you can work something out with people in Arizona before you ever let your client go back if they'll call you and give you time to do it. I've had hundreds of those cases where you got people in Alabama arrested for crimes in other states, and if they hire you, then you can generally get with those people, Connecticut, Arizona, wherever, New Jersey, wherever they're at. You can generally work something out before they have to go back to that state there. So that's criminal law. There's not many questions on the test on the criminal law. I think we've covered every one of them there. Either I read them to you or I told you that will be on the test question there. Hope you have just a basic understanding of these terms here, and I hope you see how things kind of work. And you think, well, some people say, well, how'd that happen? How'd that person get found not guilty? Well, what you saw is what was on TV and the newspaper accounts and saw on your computers and stuff, okay? I think we're talking about newspapers. I still get them, by the way. But anyway, what you read, but what went on in the courtroom you didn't see. The dynamics of that courtroom. That's what, how the lawyer, how did the person do on the witness stand? Did you put your client on the witness stand? How did they do? If you didn't put them on the witness stand, the judge will tell the jury you can't consider that that the person didn't testify because the state has the burden of proof, but that jury's looking and they're thinking, why didn't they testify? Well, they've been told they don't have to testify because the state has the burden of proof, but they look over there, You got all these considerations that you got going on. And again, when you see something happen in a courtroom and you say, how'd that happen? You'd have to be in the courtroom to see it, to see how it unfolded. Okay, well, that covers that. Our next lecture will be torts. I hope you have a general understanding of criminal law, and I hope you have a wonderful rest of the week. And thank you for listening to this lecture. Thank you.